And what they do to really kind of explain to the jury the likelihood someone else other than my client would have been the contributor to that profile is 1 in 7 quintillion. And which literally, when you write it out, a lot of times on a piece of paper, you're going to have to take 2 lines to write the number of zeros to indicate the match.
I'm always taken aback when they give that number. I don't even know how many zeros that is.
One of the key things that I was going to harp on, the state didn't test and the DNA analyst didn't test all the evidence. So what I said was that the state, when they presented the evidence, was not going to present everything or show the jury everything. I said, literally, I opened up and said, this is a case where the state's not going to show you all the evidence.
I'm listening to you and I'm like, yeah, I got to use some of this strategy. So the judge, after initially denying it, she goes and says, well, I agree that he should be relieved of his bond obligation, but these are violent crime charges. I don't want to let him out. I don't even have the authority to put an ankle monitor on him. I said, well, what if he agreed to the ankle monitor? What if you let him out and he agreed? And I turned my client, sit there, I say, would you agree to wear an ankle monitor? He was like, yeah, of course, get me out of here.
I joke with my friends that are trial lawyers that anyone that is not nervous or enjoys waiting on a jury is a psychopath.
That's right.
DNA evidence is powerful, but it's like any other evidence. You have to really appreciate and understand the context of, how it was collected and how it was analyzed and how it fits in your case.
Welcome back to the Iron Gavel. I'm Chris Washington, a trial attorney bringing you stories of justice strategy and the courtroom battles that shape lives. Today's guest is attorney David Zeitzoff. Did I say that right?
You came pretty close. It's good. It's good.
Right.
Zeitzoff, but you did a great job.
Zeitzoff. Got it. So David is a former prosecutor who now runs his own practice. He balances civil work, which includes high-stakes aviation injury cases. When people get injured on airplanes, David is one of the, as far as I know, one of the few people who does those kind of cases. He's the only person I've met that actually does it. And in addition
Suing airlines.
Suing airlines, all of them, right?
Yep, pretty much every single one.
But here, this is a podcast that features criminal defense attorneys and their verdicts. And David is one of the good guys. He recently handled a New Jersey gun case where DNA evidence seemed airtight until cross-examination revealed the truth. This story is packed with lessons on strategy, science, and the fight for freedom. But before we talk about the case, let's get to know David. So David, let's start with your background. You've been a prosecutor, you've worked in civil law, and now you're running your own firm. What drew you to criminal defense?
I've always kind of wanted to help the little guys. And throughout my career, I've kind of naturally gravitated toward that area of the practice. From both personal injury cases and doing criminal defense, I always kind of represent the little guy against either a big corporation or the police department. And I really enjoy counseling and helping people. And I think that those areas really allow me to do that.
I usually stay on topic, but I got to go off topic because what you do is something many of us who travel deal with and complain about and struggle with. So tell us about this aviation specialty you have.
So I've been doing it for over 5 years now. And it's basically personal injury with a focus on aviation injuries and in-flight or injuries at the airport, basically involving airlines. And what's interesting about it is that it's really broken down into kind of 2 types. And it's literally, if you're on an international itinerary, it's governed by what's called the Montreal Convention. And if it's a domestic itinerary, then it's governed by a standard state negligence claim with a kind of few twists or caveats related to that. And so I've sued airlines for everything related to in-flight passenger burns from coffee spills, turbulence injuries, to kind of more serious cases and injuries against pretty much every major airline, both in the US and abroad.
So David, I appreciate you educating us on aviation cases. So let's go back to criminal defense. What is one thing you would say the public often misunderstands about what we do as criminal defense attorneys?
You know what's funny is I don't think people appreciate the difference in a police officer who's been subject to cross-examination. And there's a lot of judicial opinions that cross-examination is the greatest engine for the truth. And I think it's also the greatest engine for accountability, because you can literally tell a police officer who has been subject to cross-examination and those that haven't, and their investigation kind of style and their habits are just a lot better after they've experienced that. Because, we as criminal practitioners in the adversarial system really hold the police to task and make sure that they're doing their job. And I think the general public really needs to understand and appreciate that we're like a vital cog in our nation's criminal justice system. And we really make sure that the police are doing their job every day as citizens. That's very important, something that no one should take for granted.
That's a great example. I never even thought about it like that, but we do. We make sure they do their job following proper protocol. It's no different than if any of us were to go to a doctor. Who's there to hold a doctor accountable? Somebody, some board, some agency. And in a criminal trial, it's the criminal defense attorney who's there to hold the police accountable to make sure they essentially don't do anything wrong, don't cause any unnecessary harm, right?
And I think it's funny because everyone, doesn't think about a criminal defense attorney or how important it is until they need one. And once they do, it's very important. And that's what we do, is we make sure that people's rights are protected and that the police are doing their job. And it's very important.
So let's talk about this New Jersey case. How did it come to you, and what was your client facing?
I kind of have a bit of a unique background in the sense that prior to going into civil practice, I was actually a criminal prosecutor. And then once I started my own firm, I started taking, they call them in New Jersey, pool cases, which are just conflict cases. When multiple people are charged for one crime, the public defender's office can only represent one. And what they'll do is they'll pool out or send to other attorneys the co-defendant. And so in this particular case, I was pooled my client who was charged with a gun in a car. And so this particular gun charge case was pooled to me by the public defender's office.
Why would you say this case is important and unusual?
So I think what's interesting about this case is it kind of reveals the issues and some of the problems that can arise from DNA evidence. Because I think if you look at it in a vacuum, and if you talk to everyday folks in a vacuum, they think that DNA evidence is foolproof, and that, hey, if his DNA got on the gun, or if his DNA is on an object, it means they touched, they handled, or otherwise, kind of owned the object or owned the gun. And that's not the case. And I think this case is unique because obviously there was DNA evidence. And just because someone touched or came into contact with an object doesn't mean necessarily that they possessed it as defined by the law. And I think that's important for everyone to understand kind of what DNA evidence is, what it proves, and what it doesn't prove. And I think that was very important. It's something that from the beginning, I struggled to wrap my own head around, and something that I really wanted to make sure when I was explaining it to the jury and discussing it with the jury that they understood kind of what it meant and what it didn't mean.
Tell us about your client, his life at the time. What was he dealing with personally, if anything?
So my client was a really good guy and is a really good guy. And basically, he's not someone that necessarily was like in the system day in, day out. He's a supervisor at UPS. He lives with his mother and cares for his mother, who has kind of some health issues. He's got a young son that he shares kind of custody of. And, he's somebody, if you meet regularly, you wouldn't think he was a jerk. You would think this is a good guy. And I think that those were kind of important facts and things that I wanted to show the jury and present the jury throughout the course of the case.
At some point in your case, I don't know if it was early on or later, there was a plea deal offered to your client, and you thought it was a really good plea deal, declined to accept it. Tell us about that.
New Jersey, certainly different than Louisiana or other states, including Texas, takes gun charges very seriously. And there's typically a mandatory and minimum sentence for any type of gun. And so in this case, my client from years ago had a prior that basically caused him to be what we call in New Jersey a certain person, and what other states would say is a felon in possession of a firearm. And what that meant is that potentially, kind of depending on how the judge would assess punishment after verdict, he could have been facing anywhere from 8.5 to 15 years in prison. Given that, and as I'm sure we'll go into, there was DNA evidence. His DNA was alleged to be on the gun. The state offered, prior to us going to trial, basically 1 to 3 years in prison, basically 1 year minimum, 3 year maximum term of incarceration. And given the circumstances and obviously the DNA evidence, I recommend that he take it. And he made what turned out to be the smart decision and rejecting my advice. And he ultimately rejected the case and went to trial.
That's not usually the case. Usually our advice is in their best interest, but they'll ignore us. But look, sometimes they're right. A lot of the people I talk to on the podcast, it's one of the things I always say is that my client is there not just for me to represent him. He or she is also there to assist me. And sometimes they have a unique perspective that I may have developed tunnel vision on the issue, and they're there to help. In most criminal cases, I always say the client knows more about what happened factually than I do. So I need them to help me help them.
Exactly.
So that's great.
And that's an important part of the process, is kind of involving the client and getting the client's perspective on everything.
So I know why you wanted him or recommended that he accept a plea deal is because of this DNA evidence that looked pretty damning. So let's go straight to the heart of the case. The DNA, what it showed, and how you dealt with it.
So at first, I saw the DNA evidence, and I thought there is no way to deal with it possibly. Because in essence, what happens is after the stop and after the arrest in New Jersey, they'll have technicians who are police officers typically swab various parts of the gun, and depending on the case, the bullets found in the gun for DNA. What they will do is they've developed a procedure to swab the certain areas of the gun most likely to reveal or contain DNA from people who would handle the gun. So the most likely places that you would handle the grip, the trigger, the slide, and obviously DNA is more likely. DNA we're talking about, obviously there are different types of DNA, but it's called contact DNA. It's basically when you sweat, your body will shed skin cells that can be deposited on items, and it's more likely to be deposited on rough surfaces. So they kind of, in their protocols, they're swab various areas of the gun most likely to have this contact DNA. So in our case, they swabbed the gun and they sent it off for testing. And the analysts tested the various areas that they swabbed. And when the analysts test the DNA, what they'll do is they'll develop one or more profiles. There can either be a single source, which means it's only coming from one profile, or it can be a mixture coming from more than one profile. And the single source profiles are always the ones most difficult as a defense attorney to contest, because for a host of reasons, it's less likely to be transferred and it's more likely to be kind of considered quote unquote foolproof in a court of law. And so in this particular case, there were mixtures found in various parts of the gun, and my client was considered a contributor on several areas of the gun, including like the grip and the slide, and on the trigger, which I think everyone would agree would have been the most damning place to have a profile. He was a single source profile. And what they do to really kind of explain to the jury the likelihood, and like the term that they use is basically the likelihood that someone else other than, in this case, my client, would have been the contributor to that profile is, in this case, I believe it was 1 in 7 quintillion. And which literally, when you write it out, a lot of times on a piece of paper, you're going to have to take 2 lines to write the number of zeros to indicate the match. So in essence, what they were saying is that he was a single source profile in a match for the trigger. And so that was the kind of tough evidence to get around.
I'm always taken aback when they give that number. I don't even know how many zeros that is. Do you know? After the 1?
I don't know. And to be honest, I was in trial. The prosecutor really did a good job of making the presentation as dramatic as possible. And what the DNA analyst did, which I thought was pretty clever, it was enough zeros to where she had to go to the next line on the flip chart when they were presenting it to the jury. So it looked like a ton of zeros at the time, and definitely was very compelling in my view when they presented it.
One of the things I've done with that, when they come with that number, well, at least up until this point, none of them have with a real way to deal with this. I like to point out that in the history of man, Homo sapiens, there's only been about 100 billion people ever to walk the face of the earth. So where is this number coming from? It's not reflective of reality, right? It's just math.
And of course, that's part of it. And, I think in a different circumstance, I would have probably gone down that route as well. But to be honest, I wasn't even contesting. And that was kind of part of my strategy, was I didn't really test the fact that this was a match for my client's DNA. The issue that I presented was that didn't prove that he knowingly possessed the gun, at the time of the stop or at any point prior to the stop.
Because of a concept known as transfer DNA.
Secondary transfer. Yep. And there have been, numerous studies, there have been studies from reputable journals, including the Journal of Forensic Science, about how secondary transfer, could result in someone's DNA being placed on an object, and also, how someone can falsely be accused of being at a crime scene or, basically handling an item when they never touched it. And that was kind of the gist of where I went with everything.
So I got to back up just a little bit, because your client's DNA is on the trigger. The gun is recovered from where? Tell us how the police obtained the gun.
It was from a traffic stop. And everything kind of related to the recovery, I kind of used my argument. Because in essence, what happened is my client, this was during the pandemic, and my client was traveling with his girlfriend on a local highway and was pulled over. And when they pulled him over, and this is all captured on body camera, they opened the trunk and there was a lot of stuff in the trunk. I remember he had his son's sports equipment, he had paperwork, he had automotive parts, he had clothing in the car, both his and other people's. And so the cops spent a significant amount of time going through all this stuff. And they eventually found, and they pulled back the lining of the trunk, which was loose. And in like a void above the wheel well, they found a Crown Royal bag. And inside the Crown Royal bag was the gun. And so it was kind of immersed amongst all these other things.
So we're going to come back to this, because I know in the trial, there was multiple witnesses you had to challenge, several officers and a DNA analyst. But I want to start where a jury trial begins, and that's jury selection. Based on what you learned pre-trial with the stop and the DNA and the recovery of the gun, what was your approach during jury selection?
I think there were a couple kind of unique things that kind of set up my thought process with jury selection. And what you have to understand is that New Jersey is different than other states in that the judge tends to control jury selection. So the attorneys are very much limited in the questions they can ask. Typically, the judge will issue a series of questions, and the jurors are required to answer the questions. Questions are designed, obviously, to establish if anyone is biased in any way possible. And if there are certain answers that may establish bias, then they're asked follow-up questions, sometimes by the attorney, some by the judge. And one of the questions that they asked, which I thought was appropriate in this case, because in all honesty, everyone from the police officers who stopped my client, to the folks that swabbed the gun, to the analyst that tested the gun, they were all employees of either a local police department or the local prosecutor's office. The analyst that tested the gun the lab itself is under the auspices of the local prosecutor's office. And so I kind of presented them all as kind of a part of the same group, namely like law enforcement officers. And so my focus and one of the questions that jurors are asked is, are you more or less or as likely to believe the testimony of a law enforcement witness as any other witness? And I thought that was going to be a real good window into how the jurors would evaluate the testimony of these witnesses, because any jurors that obviously would be more likely to, or believe that a law enforcement officer is more likely to tell the truth than anyone else, is someone that probably wouldn't be a great jury for us. Whereas a juror who believed that a law enforcement officer was less likely to be truthful would be someone that we would want on the jury.
So jury selection goes, how long does jury selection take?
Well, it's funny you should ask, because I'm not one in trial. I want to keep things moving. I think it's very important, to at least show to the jury that I'm not the one delaying. Jurors always, in my view, do a very good job of evaluating evidence, and they don't appreciate like time wasting. They don't appreciate lawyers that kind of like linger over things. So I try and get to the point as quickly as possible. And that goes for jury selection for me. And I was told, that most folks, when they do jury selection for this type of case, it could be anywhere from 3 to 4 days, but we accomplished it in like a day. You don't question jurors as a group, you question jurors individually. And so because of that, it does add some time, but you do get to hear each juror's response to each of these questions, including the key law enforcement question. It really did help me kind of look at each juror and decide, who was good and who necessarily wasn't,
That's a great point you made, though. I think they hold it against whoever they feel is wasting their time. Here in Louisiana, it's a little bit different. We question a jury panel. So anywhere from 14 to 35 people will be in the box, and some courthouses will actually sit the rest of the jury when they're in the audience. So they hear everything that's discussed with the first panel. But one of the things you said, it made me smile, because I distinctly remember a trial where my client and 2 other people were charged with attempted murder, allegedly shot up a motel with AK-47s, and one of the 3 was shot and the others dropped him to the hospital. So that's how they were able to make the connection. But the prosecutor called a firearms expert to explain to a jury how a firearm works. And we never disputed that guns had been shot. Our defense was our client wasn't one of the people who was there shooting. I'll never forget, I learned so much about firearms that I didn't care to know, but I had to sit there through it, and the jury was going to sleep. So after the prosecution finished, I was like, this witness testified for 2.5 hours. I got to ask something. So I get up and I asked the expert, I said, where did you drive in from? And she was like, Covington. And I was like, how far is Covington from here? She said, about 45 minutes. And I said, have a safe trip home. So I look at the jury. So they start laughing, and a couple of them are telling me thank you like under their breath. And I was like, don't waste these people's time, because most people don't want to be there to begin with. So at least you respect their time and do it.
Absolutely. And especially if you look like you're, objecting or, for no reason or obstructing things, I think that the jurors notice that as well. And so I think that that's something that, or at least I try to avoid as much as possible.
That's right. If it's not hurting me and it's objectionable, why do it? Just let it
Exactly.
go. One of the favorite parts of trials for many lawyers is opening statement. So I want to know what the prosecution did in their opening statement. I'm assuming they go first. Do they go first in New Jersey?
They do.
What did they do in their opening, and how did you respond to their opening?
It's funny because we both had kind of a simple theory of the case, and their theory of the case was, in essence, it was his car, he admitted ownership of the car, and the gun was found there, and his DNA was on the trigger. And, their opening was longer than that, but in essence, that's what it boiled down to. And the thing was, nothing that they said was surprising to me at all. And I think we all knew going in that that would be the case. The one advantage I had was that they really didn't know where I was going to go with it. And I think from the beginning, they assumed, because, they knew that there was going to be secondary transfer, and I was going to argue secondary transfer for the DNA. But I think they thought, and typically a lot of folks, what they'll argue is that when a police officer is recovering the gun, they always have to make it safe. So they have to touch the gun in some form or fashion. And if you're searching, my client's car that he owns, presumably there'll be some of his DNA in the car, and they may have transferred it onto the gun at that point. The problem was, when I was looking at the video and I was thinking about going down that route before trial, it didn't explain necessarily that in terms of the fact that there would be DNA on the trigger. And I think, to be honest with you, my theory was and my arguments were more accurate in line with kind of the evidence. And so I kind of kept that one fact close to the vest. And I tried to kind of continue that through opening. And so it was in some ways a very vanilla opening. The one thing that I wanted to focus on, because I knew the state was going to try and limit some of the testimony and kind of not go into every single detail, like in terms of what caused the officers to stop the car, why did they search the car. They weren't necessarily planning to call all the officers at first or play all the body camera footage. And more to the point, I knew most importantly, and kind of one of the key things that I was going to harp on, the state didn't test, and the DNA analyst didn't test all the evidence. They didn't test the bullets in the gun, which was important and something that I developed and really hammered throughout the course of trial. But I kept that close to the vest. So what I said was that the state, when they presented the evidence, was not going to present everything or show the jury everything. I said, literally, I opened up and said, this is a case where the state's not going to show you all the evidence. And I kind of left it at that. And I said, and I closed the ending of my opening. What I said is, listen, what you have to understand is that the state isn't required to prove, and it doesn't matter whether my client's DNA is on the gun. They have to prove that he knowingly possessed the gun and knew it was there. And those two things aren't the same thing. And the only thing I'm going to ask you to do when you're listening to all the evidence is to just think about what the state is showing you and what the state is not showing you. And at the end of the day, when you go back in the jury room, you're going to realize, and you're going to receive an instruction about reasonable doubt, that reasonable doubt can come from the evidence and the lack of evidence. And here there is reasonable doubt that my client knew that there was a gun in the trunk. And that's kind of how I left it. It was somewhat vanilla. I kind of tried to put enough information in my mind so the jury would know what to look for. But I kind of tried to keep my theory close to the vest so that the state wouldn't know and prepare their witnesses ahead of time for it.
After opening statement, we get into the witness examinations, right? The prosecution calls the witnesses and you get to cross-examine them. So before we dive into that, for somebody who has no idea what secondary DNA transfer is, how would you define it?
Primary transfer is very straightforward. If I touch an object, then there's a chance that my DNA could get on the object. That would be called primary transfer. So if I touch a cup and I deposit skin cells on the cup and leave my DNA on the cup, that's primary transfer. Secondary transfer would be when I shake someone's hand, for example, and then touch a cup. I could deposit the person whose hand I shook, their DNA on the object by virtue of the fact that they would transfer their DNA to my hand, and then from my hand, I would then touch an object. So basically, in essence, it's where there's a secondary source to transfer the DNA from the person to whatever object you're testing. And so there's secondary transfer that can occur from person to object. But then the one that I was focused on was a little different. There's also secondary transfer from person to object to object. So for example, and I'm going to use kind of my case because it can kind of illustrate how that could occur. And the evidence came out that my client basically allowed access and others to access his trunk. And in his trunk, he had a Crown Royal bag that, basically had, bottles of alcohol that he had touched and that had his DNA on it. And the Crown Royal bag was in the back of the trunk. And basically someone else had deposited the gun in the Crown Royal bag and put it in the back of the trunk. And through secondary transfer, my client's DNA, which was on the Crown Royal bag, would have been transferred from the bag to the gun. It can either occur, like I said, through like person to object, or in this case, person to object to object. And the sheriff's officers who swabbed the gun were very helpful in explaining my theory. And part of what I did was I kind of started discussing secondary transfer before the state's analyst testified. The state's analyst was the last witness. And so the folks that swabbed the gun, it's in every case, it's the same thing, because contamination is a real thing that they're always concerned about. And so they talk about wiping down their workstations because there are objects on their workstations when they examine or swab, an object, in this case, a gun. And the concern would be if their DNA is on an object, it could, through secondary transfer, go from the object to the gun. And I really kind of explained that to the jury through each sheriff's technician's testimony about the swabbing process. And so I kind of set it up to the jury from the beginning of the case as soon as those folks testified.
Can you say more about what you got out of the sheriff deputies?
It's kind of funny because I always try and keep my adversary on their toes because, everyone prepares the DNA analyst for the secondary transfer question. But the technicians, all of these folks have testified before, and that, you typically get the same sort of questions, and they're used to basically defending themselves from somehow contaminating whatever they swab. And so part of the testimony that they will always provide when they're testifying, they'll always talk about what steps they made or undertook to prevent contamination. So they'll talk about how they use gloves and a mask, and they will talk about how they thoroughly will wipe down their workstation before they swab an object or before they even place the object on the workstation. And I kind of took advantage of that, and I kind of played with that and had them really go into detail and explain, how they cleaned their workstation and the significance of that. And, obviously at first I used the word contamination, but then I kind of changed the word from contamination to secondary transfer. And I explained how contamination could occur from object to object on their workstation. And that's why they took such great pains to clean that area. And I think it really was successful because they didn't really fight me at all on it. They were
they couldn't, which was great. I'm listening to you and I'm like, I got to use some of this strategy. What
it was great, yeah.
Deny their own protocol and procedures, so they couldn't fight.
Exactly. And the big thing was because I knew going in that they hadn't tested the bullets, and my theory was that the bullets themselves were the most important pieces of evidence in the case because they were found inside the gun, both, obviously in the chamber and then 10 in the magazine. And the reason why they were the most important pieces of evidence is because they were impervious. Their location in the object was impervious to secondary transfer. So if my client's DNA was on the bullets, there's no way I could argue there was secondary transfer.
That's right.
And the technician that swabbed the gun also swabbed the bullets. And she then sent it to the lab, and the lab technician, I swear, in the report, like italics for everyone to see clearly, items 7 through 9 or whatever it was, they were on the list, were not tested. And so she made the conscious decision not to test the bullets. And I knew, what she says and what they argue is that, like I said earlier, DNA evidence and DNA, transfer in terms of contact DNA, whether it's primary or secondary, is more conducive on kind of rough surfaces because it's easier to get your skin cells on rough surfaces. And so their argument is that it kind of doesn't make sense to test the bullets because they're smooth. And so you're not as likely to get a DNA profile or develop a DNA profile from the bullets. But what happened is, and what was some really good evidence, the sheriff's technician that swabbed the gun also swabbed the bullets. And what she said, first off, is that she swabbed the bullets through the protocol that was developed by her office, the sheriff's office, in conjunction with the lab. Basically, at the direction of the lab, she swabbed these bullets. And not only did she say that she swabbed the bullets, but what she also did is she swabbed the areas of the bullets most likely to reveal DNA or, basically recover DNA evidence. And she specifically said that there was a certain area of the bullets where there was kind of raised, I think it was like the initial, I think they're like Winchester ammunition. So it would have been the W for Winchester on the bullets. And that area is raised, so it's kind of like a rougher area of the bullet. And those are the areas that she swabbed, which most likely have contact DNA. And so I kind of set her up even before the analyst testified. I asked her those questions about where she tested, why she tested it. And like you said, the policy and procedure, which in this case was developed by the very lab for whom the lab analyst that was later testifying saying, there's no need to test the bullets, that they developed. And they basically told the sheriff's officer to swab the bullets, but then they didn't test it. And so that was kind of like how I approached it and how I handled the DNA evidence.
After you finish with the sheriff deputy who swabbed the bullets, is the analyst, the DNA analyst, the next person?
Basically, the order of witnesses was first, obviously, the patrol officer did end up calling the patrol officer who recovered the gun, who was the partner of the first witness. Then, obviously, the technicians who swabbed the gun and the bullets. And it ended with the analyst who tested the gun and chose not to test the bullets.
Before we talk about the analyst, I got to interject this just in case the audience doesn't know. What we criminal defense lawyers typically do is sequester the witnesses so they can't hear what each other is saying to the jury. So we got the officer who swabbed everything, and now the analyst comes in, and the jury is aware of what the officer swabbed, why the officer swabbed it, and the connection to the lab. And now we get the DNA lab technician in there to testify and tell us what happens.
I got to give her credit. She was a good witness. A lot of what she said, I think, came across to the jury. And the prosecutor did a very good job of basically getting the points across that he wanted to through her. But my thought process from the beginning was really, like we talked about, to show, because remember, the theme of the case is, what are they hiding? What didn't they show you? And so after she testified and she put those, 2 rows worth of zeros on the flip chart, I came in and literally the first question, and the one thing that I was kind of surprised at, because, a lot of times prosecutors, what they'll try and do is they'll try and explain away their bad evidence. And so they didn't mention the bullets on direct at all. And I had planned to kind of end discussing the bullets, but I really wanted to kind of signal to the jury the significance of the bullets, the fact that they didn't test them whatsoever, and also, my thoughts about how the prosecutor, by doing so, was still not showing them everything, kind of hiding evidence. And so I walked up to the analyst, I remember, and I took out, they have the analyst report, the first page includes an evidence inventory. And I just walked up to her and I asked her to point to, I believe it was items 7 through 9, which were the bullets. And I just want to get to the 1,000-pound gorilla in the room. Look at items 7 through 9. You would agree with me that you didn't test those items. She looked at it for a second, and she knew I was going to be asking her questions about that. So she acknowledged that she didn't. And I kind of just smiled at the jury. And I certainly didn't get any frowns or any confused looks from the jury. They knew what I was trying to say when I did that. And then I went into my exam and I ended with that. And the one thing I will say that's interesting to me is that, as a practitioner, I always review myself and I always kind of review my performance and I always want to get better. And I do feel that, she was a difficult witness. And at the time, I was kind of questioning myself if I should have done more, because there were basically 3 key questions beyond the bullets that I asked her that I thought were very important. First, I wanted her to acknowledge that secondary transfer was a viable and legitimate theory. 2, that she couldn't tell the jury whatsoever whether my client touched the gun. And 3, she couldn't tell the jury whatsoever how my client's DNA got on the gun. And she ultimately acknowledged and answered yes to each of those questions. But what she did is she kind of rolled her eyes, paused, and then answered yes to each of those questions. I thought it was clever because I think what it did was it conveyed the message to the jury of, yeah, I guess it's possible, but this is, in essence, not likely at all. And, thinking back on it, it's kind of one of those things that, it's a response. And in the moment, you kind of have 2 options. You can either really challenge her on the nonverbal stuff that she's doing at the time, or you can save it and argue it in closing. I chose to kind of do the latter. And ultimately, obviously, it worked out. But at the time, I was, kind of beating myself up and wondering if I should have kind of gone after her more for her theatrics. So that was kind of like a little bit of kind of like an interesting kind of back and forth with her during the examination. And at the end, what ultimately happened, and I think kind of one of the big things that she gave us, because she tried to explain why they didn't test the bullets. And in essence, and I forget exactly how she said it, what she said exactly, But the gist of what she said is that they had to prioritize certain cases. And this was only, a gun case. And so obviously it was something that they weren't necessarily prioritizing, at least compared to maybe other cases, the implication being obviously homicides and shootings and things of that nature. But, I really kind of used that in my closing when I really just hammered her about that, how she didn't prioritize this case. But I said, and I followed up with, this case is my client's priority, and he's on trial here. He's facing serious criminal charges. And, this is what he cares about, and just really trying to contrast how, the state didn't even do the bare minimum, test everything that was sent to them pursuant to their own protocols. And because they didn't care about the case, as opposed to my client, who this case is his entire priority. It's what he cares about. Sometimes you might draw an objection in closing. So, sometimes what I'll do is I'll kind of emphasize that without saying those words. They don't even test the bullets, which were impervious to secondary transfer. There's the reasonable doubt, And I really kind of try to tie that in and tie in specifically that testimony about her prioritizing other cases.
I'm going to have to use that. Not to prioritize in other cases. If that comes out in my trial, I'll use it. But the way you dealt with the DNA, the secondary DNA transfer, the failure to test items that could have had DNA that would have been protected from secondary DNA transfer, I think that was great. That was just a great strategy.
Thank you.
To deal with what many lawyers would have approached as, hey, dude, they got your DNA, it's on the trigger, we better take this deal. Even after the client, like in your case, your client declined, I've seen lawyers be persistent in telling the client how they need to take a plea deal. And it appears you didn't do that. I don't do that. I'll tell them what my opinion is, but if they want to roll the dice, I remind the client that no matter what, I'm going to stand and fight with you, but I'm not risking anything. I go home no matter what, and you don't. But
that's my philosophy. I'm always of the opinion, and I tell them straight up that basically it's not my job to tell them what to do. It's my job to give them an informed opinion about what I would recommend. And most importantly, though, it's really just my job to let them know kind of what the consequences are, what they're facing, what evidence the state will use so that they can make a fully informed decision. Because it's their decision and it's their life. 1000% agree with you on that.
Since we're talking about that, it brings me to a point I've discussed with many lawyers on this podcast and just in general. So I've been a lawyer for October will make 18 years. And I just started doing LWOP cases, life without parole, for a public defender's office in one of the parishes in Louisiana. And one of the things I've always heard people say prior to doing the LWOP cases, and even more so now, is that public defenders work with the prosecutors, which I tell people I've never met one that does. Mm-hmm. But they also don't care. Honestly, I've met some that don't care, but I've met a great deal of lawyers who do public defense work that genuinely care. Is that something you've had to deal with in this case because the client rejected your advice, or other cases in general? And
sure,
how do you deal with it to show like, look, I understand the perception, but that doesn't apply to me?
You know what's funny is, and it's kind of pretty common, is that, to be honest, you can say whatever you want, but what typically will change, and to be honest, it changed in this case, is when you actually start getting in the courtroom and they see your work, that kind of melts away. And so in this case, I certainly had that issue. I recommended that he take the deal at first. And then we had some pretrial motions, including one of the officers testifying. And I kind of caught him in a few kind of misstatements. I kind of held his feet to the fire when I questioned him. And after I was done, my client said, "Oh, wow, you tore him up pretty good." And it wasn't an issue after that. I think, typically, as much as you want to just be able to reassure someone, that you have their interest at heart, typically, when you get in the courtroom and you argue on their behalf and they see your passion and they see you questioning a witness, arguing with a judge, kind of making a cogent point on their behalf, they appreciate that, and the feelings will typically change. Not everyone, but a large majority of folks, that kind of is how things typically shake out for me.
I tell people especially young lawyers, but I tell clients all the time, I said, whatever discovery comes in your case, I'm going to read it. I'm going to come visit you at the jail if you're in jail, or you're going to come to my office and we're going to talk about it. So that kind of gets them past that. But a classic example, I had court this morning, 3-defendant case, and the prosecutors filed the charges back in December or January. They filed the charges in January and February, dismissed the charges in August, and refiled new charges the same day. Well, my guy has been sitting in jail, my guy and his 2 co-defendants, the entire time. And the other 2 lawyers filed a motion to quash the indictment, which I didn't think that was the appropriate remedy. So I filed a 701 motion to get him relieved of his bond obligation. And I'm kind of mild-mannered. People that know me know that I'm not a pushover, but if you just meet me, I tell people my boys have deeper voices than I do, so I'm kind of mild-mannered and unopposing, but that doesn't mean you're going to push me around. So anyway, the judge calls the case up, and she says, for any of these defendants, did anybody file a motion to quash on any other grounds other than failure to institute prosecution? Because those are denied. And I said, well, Judge, I didn't file a motion to quash. I filed a 701 motion for my client to be released. She said, that's denied also. So I look at her, I started smiling. I said, Judge, and this is literally how I did. And she was like, would you like to be heard? I was like, yes, absolutely. So anyway, I make my argument that the jurisprudence supports my position and my client should be relieved of his bond obligation. And the prosecutor, in their response to the quash, kind of conceded that the appropriate remedy is release of bond obligation. So the judge, after initially denying it, she goes and says, well, I agree that he should be relieved of his bond obligation, but these are violent crime charges. I don't want to let him out. I don't even have the authority to put an ankle monitor on him. I said, well, what if he agreed to the ankle monitor? What if you let him out and he agreed? And I turned my client, sit there, I say, would you agree to wear an ankle monitor? He was like, yeah, of course. Get me out of here. So
of course, get me out of jail. Yep.
She set the bond at $5. It was 7 charges, so $5 each. He has to post a $35 bond, and he's been in jail since December, and he has to wear an ankle monitor when he gets out. And then the other 2 defendants, they
join in your motion.
Yeah. They adopt my arguments. Afterwards, my client, he couldn't thank me enough, and then he was like, you kind of helped everybody. I was like, yeah, kind of. But that's just showing them, like, the judge had already denied it. I could have just sat down and taken it or told him, I'm sorry, we'll keep fighting. Yeah. But I knew I was right on the position, and I wasn't going to back down on it. I told the judge, look, Judge, if I have to, I'll take a writ on this. I really didn't want to take a writ. I got enough stuff to do. I just want the right ruling for the right reason. And this is a conflict case, so it's not a private client. I took a few cases down in New Orleans because it's my favorite city in the world to visit, and I'm looking to buy a house there. But this is one where I'm appointed, and the guy now knows that I'm in his corner no matter what.
As soon as you get a big win in a case like that, it typically will change overnight. Yep. And all of a sudden the client, I actually just got a guy out yesterday and kind of similar type feelings. He's talking about potentially hiring a private attorney, this, that, and the other. And then you get them out and all of a sudden
you're the man.
You're their best friend. So, yep, exactly.
So let's talk about the most difficult part of a trial, at least for a criminal defense attorney. And that is deliberations, waiting on the jury to bring back a verdict. My hands start to sweat. I get nervous. I'm not going to say I never get nervous during a trial, but that is the point in time where I'm the most nervous because the case is completely out of my hands. So I want to know about you and your client during deliberations. What was his demeanor?
I will say, I joke with my friends that are trial lawyers that anyone that is not nervous or enjoys waiting on a jury is a psychopath. Is the most nerve-wracking time. And this time, to be honest, I did really feel that we got our points in. To be honest, I expected the jury to be kind of nodding along more with the prosecutor during closing. This jury was very receptive to everyone, and they were really listening and attentive. But I was surprised at how attentive they were during my closing. And I was like, wow, I actually kind of thought to myself, wow, because everybody, when you have a single source profile on the trigger, the DNA analyst starts writing those zeros and it goes to the second line. Everyone in the courtroom is thinking the same thing. And to be honest, in New Jersey, obviously we have felonies, we call them indictable crimes, but we have felonies that are stacked in various degrees. So first degrees are the most serious, then second degrees, third degrees, and fourth degrees. And first and second degrees carry with them the presumption of incarceration. And so what that means in the impact in cases like mine is that if your client goes down on a second degree charge, and certain persons in unlawful possession of a handgun are both second degree charges, such that if my client is found guilty of possession of the gun, there's a very, very good chance that he's going to go in custody the minute the jury pronounces the verdict. And everyone knew that. It's part of what you have to, inform your client of, when you're speaking with them about what happens in the trial. And so my client knew about it. And what's funny is just the timing of the trial, the way things work. We closed on a Friday afternoon, like 1:30. After you're done with closing, the judge will read a charge, basically the jury charge, the instructions to the jury. And it lasts about 30 to 45 minutes easy. So in this case, the jury didn't start deliberating until like 3:15, 3:30. And everyone, including myself, was just assuming, oh, it's going to be a quick verdict. They're going to come back and convict my client just because of the DNA evidence. And I had childcare issues. I got 2 young kids. So I had to go pick up my kids a little early that day. And so my only goal was to get my client to the weekend so he would have one more weekend before, the verdict was pronounced the following week. And so I remember we close, the judge reads the charge, and the jury goes back to deliberate. And, like a lot of other places, they'll send notes when they either, have a question, they need readback, or pretty much anything. That's how they communicate, is through a note. And we got a note within like 5-10 minutes of the jury being back there. And it was that they wanted readback of testimony. And it was of the DNA technician that swabbed the gun and the bullets. And so when I heard that, I thought, oh, that means my client's going home for the weekend. He gets one more weekend before he, potentially has to deal with the verdict the following week. And so we were pumped about that. And so he got to spend, some additional time with his son. And so then we came back the following week, and literally within an hour of the jury basically hearing the testimony of the technician who swabbed the gun and the bullets, they came back with a verdict. Literally an hour. Basically, it turned out to be about an hour of deliberations in total.
We don't get readbacks.
Well, normally. Okay. Well,
yeah, it's terrible. 2 things. They don't get to hear testimony read back to them, and they don't get to take notes.
Oh, wow.
Juries in criminal cases cannot take notes. They can take notes in civil cases. Imagine that. Now, here's the deal. They can take notes if both sides agree. The prosecution never agrees. Mm-hmm. In Louisiana, if the jury were to come out and say, we want to hear this officer's testimony again, the judge would instruct them that they have to rely on their memory. And that is not how the real world works, right? None of us have perfect recall.
So the way it works in New Jersey is that there's not a court reporter assigned. Instead, they have a recording system in every courtroom. It's called CourtSmart. And so what you'll do is, and part of the assignment that I had was with the prosecutor, I had to listen to the testimony again and basically assign and agree to, like, this is the portion of testimony that they requested, and it's actually played back to them. And so, imagine the feeling of deliberations where, you're already kind of nervous and not feeling so hot. And then, one of the things for me, like everyone else, is then you have to hear your own voice questioning the witness, thinking about all the other questions you could have, should have asked.
That's right.
And it's always kind of a tough process. And the other thing that was kind of funny is that typically, when a jury's out for an hour, especially in a case like this with DNA evidence, they come back with a verdict. A lot of times as a defense attorney, you're not thinking that's good news. And so, usually the rule of thumb is that shorter deliberations are better for the prosecution. So, when you have the DNA evidence, you have the jury deliberating for an hour and coming back with a verdict. When they came back from a verdict, my nerves and my blood pressure was through the roof at that point. And like we talked about, because this was a second degree crime, with a presumption of incarceration, I'm thinking, knowing that when the verdict comes out, if he's found guilty, he's going into custody that very minute. And so as the jury proceeds into the courtroom, you try and look at them, you try to get a gauge of where they're at. Is anybody smiling with you? Is anybody, kind of looking at you, nodding at you?
Avoiding eye contact.
Mm-hmm. I didn't get any of that. I couldn't really read them as to where they were at. And so basically the jury filtered in, and then basically my client was sitting next to me. They asked us to rise. He kind of was obviously at that point very nervous. And because he was if found guilty, he was about to go into custody. There were between 5 and 8 sheriff's officers surrounding my client, literally about to place cuffs on his hands when the verdict comes out. And technically he was charged. The way that it works is that you would charge him with unlawful possession of a handgun, and then they would charge him in a subsequent kind of hearing with felon in possession of a firearm, where they would find out that he had a prior conviction. Is that, obviously you don't want the jury to hear about the prior conviction, the regular trial, because it could taint their deliberations and could prejudice my client. So they wait until the end.
We have a law in the books which is routinely charged. It's felon in possession of a firearm.
Yeah.
So the jury
Same in Texas.
knows,
they have it too in Texas.
The jury knows going in if you're a convicted felon. I love the way you guys do it. I can't imagine Louisiana would ever do anything like that. It's too fair.
I think the issue that they would have, right, and I think that I'm guessing kind of, in my experience in Texas, having, worked there as a prosecutor, is that they can't bifurcate it because there's no other charge to hear first on the felony level, because obviously possession of a firearm, if you're not a felon, is certainly not a felony in Louisiana or Texas. Whereas in New Jersey, possession of a firearm, without a permit, even if you're not a felon, is still a second-degree crime with a presumption of incarceration. So they deal with that charge first, and then they kind of have a mini hearing and a mini trial with the same jury for the felon in possession of a firearm charge, which is after that.
Well, the day you turn 18 here, you can go out and get a gun. No permit, no anything. It's absolutely insane.
A little different in New Jersey. But what was kind of interesting and funny, well, not really funny, but just what kind of occurred here with the verdict, the jury proceeded in, and the forewoman basically was supposed to read the verdict. And technically, he was charged with unlawful possession of a handgun, which was the first count. And then he had an extended magazine, they call it a large capacity magazine, which is a separate felony charge, which was the second count. And basically, the judge will ask the foreperson, Madam Foreperson, how do you find as to count one? And literally, while this is happening, the sheriff's officers are hovering over my client with the cuffs ready to go, ready to put him into custody. And she says not guilty. And everyone is in shock at that point, because I think everyone expected, like I said, with the DNA evidence, that it would come back guilty. And to be honest, I was surprised too, and I was a little shocked. So I thought that I misheard the forewoman when she pronounced the verdict. So I waited for the second count, and when she said not guilty a second time, then I thought, okay, actually, I was correct. She did say not guilty. Obviously, in my experience, the moment of a verdict is very much a high drama situation for everyone involved, but especially my client. And, my client breathed out a huge sigh of relief. We hugged, and I think that, he really appreciated the moment and the fact that he was going to be home with his son. And, that kind of hit home for me after that point.
So my kids' age ranges is crazy. My oldest is 22, and my youngest is 3.
Oh, wow.
But
oh, wow.
There's only one girl. There's 6 boys and a girl. But one of the things I tell the younger kids is, because they ask so many questions, that what we do as lawyers is similar to what doctors do. We save lives. Like, at least in this case, you saved your client potentially several years in prison, a total disruption of his life, right? He has a good job with UPS. He's a father. It would have adversely affected him and his child. So you saved his life and impacted several lives, which is great, man.
He gets to see his son graduate high school, gets to see and be with his son. And, basically he would have missed the formative years for his son. And, as a father myself, that kind of hits home. That kind of really kind of, justifies what we do and kind of left me with a nice feeling at the end of the day after that case.
So looking back on this case, what would you say you learned when it comes to the power and the limitations of DNA evidence?
I think the one thing I would say is that DNA evidence in a lot of ways, and speaking as a practitioner, as a trial lawyer, DNA evidence is powerful, but it's like any other evidence. You have to really appreciate and understand the context of, how it was collected and how it was analyzed and how it fits in your case. Because, here the one thing was, and the important thing that I kind of really harped on, in addition to, attacking what's the theory of secondary transfer, was I really focused on the trunk itself, the trunk of the car, that is. And because I think that the trunk, like, just opening up the trunk and looking inside, there was like a story there. There was a narrative there. My client clearly had lent his car to other people. He had allowed other people access to the trunk. And, as the cops were searching through it, and you could see on body camera footage, they pulled, paperwork belonging to him, paperwork belonging to his girlfriend. And my client was a really big guy. At one point, the cops pulled out skinny jeans, and I kind of paused the video during my closing. And I pointed at the skinny jeans and I said, no offense, but there's no way he's fitting into those jeans. I think the jury kind of appreciated it. And because the point I was making is that it wasn't just him that had access to the car. And that blew up because I think a lot of prosecutors, the gun's in their car, they own it, boom, open and shut case. But I kind of, through that, I showed that, hey, someone else was there. Someone had the opportunity to put the gun there. And then, the DNA evidence kind of fit into that narrative. And especially when you talk about the analyst failing to test the bullets, the one piece of evidence that was impervious to secondary transfer, that kind of really, I think, hit home for the jury and fit within the overall narrative that I presented to them. And I think that that's kind of like the lesson, is that there's no charge and there's no crime in this country where an element of it is that someone's DNA is on an object or is on an item. Instead, it's obvious that they either knowingly, possessed an item, or that they, fired a weapon. It kind of, the DNA is not part of the state's proofs. It's part of the narrative. And how you shape the narrative and how you explain how the DNA evidence got there, either through contamination from the police officers, secondary transfer, or otherwise, is what's important. And the fact that you have, DNA evidence on something doesn't necessarily mean one way or the other that it's a slam dunk. It's just a part of the case. It's not something even that the prosecution has to prove at all.
I would say that what you did in this case is, many lawyers would have ran away from this, would have shied away from it, would have plea bargained.
I kind of wanted to at first too.
This is a great outcome. I don't think I've interviewed anybody that's really challenged DNA to the particularity that you did and was successful. I learned a lot talking to you today in ways I can deal with DNA evidence in the future. So I appreciate you coming and do that. More important than me are people in New Jersey. That's the only state you practice in, New Jersey?
My criminal practice is exclusively pretty much New Jersey. In terms of the personal injury and aviation personal injury and other personal injury cases, I'm kind of actually practicing throughout the country, and I'll go wherever, people are injured and help them out throughout the country.
So if people need to find you, what's the best way they can find you and connect with you?
I think the best way to find and connect with me would be through my firm's website, which is www.zeitzofflaw.com, and that's ZEITZOFF law.com. And I'm on Google, and if you Google Zeitzoff Law, I'm pretty sure I'm the only one that comes up.
Your name is very unique and rare, as far as I know. Maybe, I don't know if it's rare in New Jersey, but I've never heard the last name.
It's pretty rare.
It's not like Washington. It's a double whammy. It's Christopher Washington. So when I was in law school, I applied for a job at UPS while I was in law school, just to work in the warehouse, actually, because the district manager or regional manager for UPS would go to the same coffee house I would go to the study. She would go there and have coffee. She promised me a job because we would talk. And I didn't get a call, so I called her. I was like, hey, what's going on? Nobody's called me. And she said, oh, give me a minute. I'll call you back in about 5 minutes. And she says, we can't hire you because there's a warrant for your arrest in North Carolina for armed robbery. And I was like, yeah, that's not me. So I say that's just can they check the birthday, the social or something?
I know.
And I've been pulled over by cops for like speeding. I remember towards New Orleans, this cop pulled me over and give him my license registration. I was a lawyer at the time. And I'm like, why the hell is he taking so long? So he comes back and he was like, sir, your name, there are a lot of Chris Washingtons who are wanted. And I say, well, I'm not one of them.
I certainly don't have that problem. The list of David Zeitzoffs in America is very short. So that is not a problem I have.
All right, cool deal. Well, thanks, David. I know it's Friday afternoon. It's 4:11 here in Louisiana. So is it 5:11 where you are?
It is time to get home to the wife and kids, but I appreciate you having me on and talking about my case.
I appreciate you coming on.
Thank you. Thank you. Great.
Folks, there it is again. This was an amazing story of a lawyer taking DNA evidence head on. Many lawyers would have backed down, ran away, given up, given in, and essentially begged the client to take the plea deal. Not David. David fought for his client to the very end and was successful in keeping this man out of prison. The jury returned a not guilty verdict. His client got to go home that day and spend time with his family. For more stories like this, stay tuned and subscribe. The Iron Gavel, signing off.